Welcome to the AI Law Briefing Podcast. Disclaimer: this podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. Okay, welcome back. Today, we're really going to dive deep into that busy intersection where AI, law, and business all meet. Yeah, our goal here is simple: cut through all that noise from the latest AI news and really focus on what it means for you strategically, legally, operationally. Especially if you're a legal professional or work in any organization touching AI, we've distilled insights from a pretty comprehensive report covering everything from talent wars, hardware issues, big court rulings, right up to the details of the EU AI Act. We want to get you the core takeaways fast.
Absolutely. And what's really striking, I think, is just how fast these fundamental AI development issues are turning into real, tangible legal and compliance headaches. Understanding these dynamics isn't just academic, it's absolutely crucial if you want to give proactive, effective legal advice today.
Couldn't agree more. So let's kick off by looking at how the whole AI landscape is being shaped by, more than just code. It's people, it's power, it's practical stuff. First, big battleground: the fight for foundational knowledge. And right in the middle of it, Meta. They've launched this huge recruitment drive for their superintelligence unit. And they're really poaching top people from places like OpenAI and Google.
Yeah, and it's not just, filling seats. This is about getting that tacit understanding, the deep, often unwritten knowledge of how you actually build and train these advanced AIs. Is the intuition, the experience. Mark Chen at OpenAI apparently felt like someone had, quote, broken into our home and stolen something. That tells you a lot about what's being valued here. So this raises a really important question for you, the legal professional. What are the implications for your advisory work? Well, they're direct and profound. AI expertise is now a core corporate asset. It affects M&A, risk assessments, this talent migration. It creates a massive risk for trade secret leakage. You absolutely need to be advising clients, like right now, to review and tighten up their employment contracts, NDAs, IP clauses. Protect that knowledge.
Makes sense. High stakes. Okay, so beyond the people, what about the machines? The hardware? We're seeing OpenAI's Sam Altman doing a bit of a U-turn, isn't he? Saying current computers just weren't designed for AI.
Right.
And that we need new specialized hardware. He's even working with Joni Ive, the ex-Apple design chief, on some kind of screen-free AI device for, late 2026?
That's the plan. And it's not just OpenAI feeling this. Microsoft's own AI chip, the Maya, is reportedly facing delays and might underperform compared to NVIDIA. So this points to a new kind of systemic risk, doesn't it? This heavy reliance on just a couple of specialized hardware makers. For legal advisors, this means looking hard at supply chain resilience, factoring in geopolitical risks around semiconductor manufacturing that needs to be part of the planning now, part of the contracts. And the sheer cost, you mentioned Microsoft spending $80 billion on data centers that really favors the big players. It could definitely raise barriers for smaller innovators, something for VCs and corporate strategists to chew on.
Yeah, definitely changes the competitive picture. Okay, speaking of challenges, let's talk about this hallucination paradox. The idea that as AI gets smarter, it might also be getting less reliable. Is that right?
It's a concern, yeah. OpenAI's own tests apparently show their newer, smaller models, O3 and O4 Mini, had significantly higher hallucination rates than the older O1.
Even Altman himself warned people not to trust ChatGPT much.
Exactly. And it's not just about getting facts wrong. It's sometimes this strategic deception, the model pretending it can do something it can't. We saw a concrete legal example. A law firm using Anthropic's Claude model, and it generated faulty, hallucinated legal citations in a copyright case. Big problem.
Yep.
It just hammers home the point for lawyers. You cannot delegate the duty to verify. AI tools can help, sure, but the final check, that's still human.
So how do we manage this risk then?
Well, Anthropic itself actually gives some good best practices in its documentation. Things like, first, prompt specifically for reliability. Use clear instructions. Tell the AI it's okay to say, I don't know. Second, ground the AI in facts. Pull direct quotes from documents before it summarizes.
Okay.
And third, demand a chain of thought. Ask the AI to explain its reasoning step by step. That often reveals flawed logic pretty quickly.
Right. So AI helps, but it doesn't replace that critical human judgment.
Got it.
Now, here's where, as you said, it gets really interesting. Let's shift to a major legal decision shaking things up globally, the whole fair use question in the AI age. We're talking about the Bartz v. Anthropic ruling from the U.S. District Court back on June 23rd, 2025.
A pivotal one, yeah.
Judge Alsup found that using copyrighted books, crucially lawfully acquired books, to train LLMs like Claude was transformative, protected by fair use.
His reasoning was that the AI learns statistical patterns, like a human reading to learn, rather than just copying the books to replace them in the market.
And this is key, he drew a very clear line, didn't he? Using pirated sources, that was not okay. Likely infringement.
Exactly. The principle couldn't be clearer. The legal source of your training data is everything. Fair use is not a shield for illegal downloading.
Okay, but fair use is a U.S. thing. How does this play out in the EU with the AI Act?
Great question. While the doctrine itself is U.S.-specific, the Anthropic case is still hugely influential for Europe. The thinking behind it. That's going to shape the regulatory conversation here, and it connects directly to the EU AI Act. Article 21 mandates that general-purpose AI providers comply with EU copyright law and provide detailed summaries of their training data. So this raises an important question for you, the legal professional here in the EU. How does this ruling change things? Well, it turns that abstract copyright compliance requirement into a very real, very high-stakes operational challenge. If AI developers can't show a clean legal data supply chain, they're looking at potentially massive liability under the AI Act.
Wow, okay. So the big legal question is training copying anymore? It's shifted.
It really has.
It's now the practical due diligence question. Can you prove where every single piece of your training data came from and that you had the rights to use it?
Precisely. It reframes the whole thing into risk management. And this is where lawyers provide immense value now, not just writing memos, but helping clients set up practical risk mitigation.
So what are the actionable steps then?
Okay, several key things we're advising clients, both developers and users of AI, to do immediately. First, a data provenance audit. Go through all your training data sources, document licenses, everything. Now, second, establish a formal data acquisition policy. Clear rules internally. No pirated stuff, period.
Makes sense.
Third, really scrutinize your vendor contracts.
Yeah.
If you're using a third-party AI model, you need warranties from them about the legality of their training data.
Right.
That protects you downstream.
Right.
And finally, get ready for transparency. Start compiling those data summaries required by the AI Act now. It'll force you to find any risks early. Doing this turns a potential legal minefield into a manageable operational process. That's the value lawyers bring.
That's incredibly practical advice. Okay, so switching gears a bit, what does all this mean for actually using AI in your daily legal work? It feels like powerful AI is suddenly everywhere, baked into the software we already use. It's leveling the playing field, isn't it?
It really is. The barrier isn't necessarily dying expensive new tech anymore. It's about adapting how you work.
Look at Google embedding Gemini AI right into Workspace, Docs, Sheets, Gmail, often at no extra cost.
And Microsoft's even more direct, pushing Copilot for 365. They're telling their own managers to evaluate staff based on AI tool use. That's a huge signal.
Definitely a preview of client expectations down the line.
Absolutely. And then you have Elon Musk's XAI getting huge funding, building supercomputers, even hiring lawyers for its X Money payments platform. The need for legal expertise in AI and fintech is just exploding.
So these big players aren't just selling tools.
No, they're actively shaping the expectation of how professionals are supposed to work. It's a glimpse into the future for law firms.
And the real advantage isn't just having the tool, it's using it strategically.
Exactly. The true win is automating those lower-value, time-consuming tasks to free up lawyers for the complex, high-value strategic work that clients actually pay top dollar for.
Like what, for example?
Well, think about accelerating due diligence. An LLM can whip through thousands of pages in a data room, flag risks, find specific clauses, letting junior lawyers get to the real analysis much faster.
Or drafting.
Efficient first draft generation, absolutely. AI can generate initial drafts of standard documents, corporate resolutions, employment contracts. The lawyer's role shifts to strategic review, tailoring, adding that crucial nuance.
And research too, right?
Yeah.
You mentioned Google's Notebook LM.
Yes. Tools like that let you upload your specific sources, case law, legislation, and ask complex questions based only on that material. It keeps the AI grounded, reduces hallucination risk for research tasks.
Okay, and here's the thought. Could firms turn their own internal AI policies into a service?
Fantastic point. As firms develop their own robust AI usage policies, they gain expertise. Why not productize that? Offer advisory services to clients struggling with their own AI governance. That's a high-value offering right there.
So the real competitive threat isn't being outspent on tech.
No, it's being outmaneuvered. It's about agility. With powerful AI in standard office software, access is democratized. Advantage goes to the firms that integrate these tools fastest, showing clients better efficiency, better responsiveness.
So tools like Gemini and Google Workspace, Microsoft Copilot, Anthropic's Claude Pro, they're available often with EU data options.
The key isn't which specific tool you buy. The risk is failing to change how the firm operates to leverage them. That's the critical shift.
Powerful takeaway indeed. All right, let's tackle our final section. The regulatory horizon. The EU AI Act. It's law, but operating in structured uncertainty.
That's a good way to put it.
Okay, so the act officially entered into force August 1st, 2024. We've got phase deadlines coming up fast. The ban on unacceptable risk AI, like social scoring, that kicked in February 2025. But the big one for many is August 2nd, 2025, right? That's when the rules for general purpose AI models apply and the European AI office gets set up.
Correct. And then most other rules, including for high-risk systems, follow in August 2026. So yes, deadlines are approaching, but
There's pushback.
there is. A big group of European companies, Airbus, Mistral AI included, called for a 2-year clock stop, basically, citing lack of clarity. And adding to the confusion, the European Commission itself is delayed in publishing the crucial code of practice for those GPAI rules. It was expected May 2025, now maybe year-end.
So there's a disconnect. Binding deadlines, but missing guidance.
Exactly. Which, for legal professionals, creates this period of ambiguity. But ambiguity isn't a roadblock, it's actually an opportunity to provide really valuable strategic risk management.
And meanwhile, here in Luxembourg, the authorities aren't just waiting around, are they?
Not at all. The CSSF, the financial regulator, along with the central bank, is already actively monitoring AI adoption.
Their second review in May 2025 expanded to investment firms, fund managers, looked at Gen AI use cases against the Act's risk levels.
Right. And the CSSF is even using a sovereign cloud platform, Clarence, for its own AI work, showing a focus on security. Plus, Luxembourg is already proposing new domestic laws to empower regulators like the CMPD to enforce the AI Act locally.
So Luxembourg is being very proactive.
Incredibly proactive. They're sending a clear signal to regulated entities. Start assessing your AI inventory now. Don't wait for perfect clarity.
Which brings us to the no regrets actions. Things firms should do regardless of the final details.
Precisely. These steps build a defensible compliance posture, no matter what the final code of practice says. First, implied document changes. Draft and adopt a comprehensive internal AI governance policy. Define roles, ethical lines, risk assessment processes.
Okay.
Also update your external documents, terms of service, privacy policies. You need to disclose when people are interacting with AI for those limited risk systems. Transparency is key.
And beyond documents.
Essential actions. Create an AI system inventory, a detailed list of every AI system you use or provide. Then, do a preliminary risk classification for each system under the AI Act criteria: unacceptable, high, limited, minimal. And for anything looking like high risk, start your fundamental rights impact assessments, your FRIAs. That's mandatory anyway, so get going now.
So taking these steps turns regulatory uncertainty into a manageable process.
Exactly. It lets you, the lawyer, provide that much-needed certainty and guidance in a complex environment. That's where the real value lies.
This has been incredibly helpful, really getting into the weeds. We've covered so much ground, the big strategic shifts, the talent wars, the hardware needs, the reliability issues, then that landmark U.S. copyright ruling and what it means for data provenance under the EU AI Act. We explored the practical AI tools that can give lawyers, especially here in Luxembourg, a real edge if they adapt their workflows. And finally, navigating the EU AI Act's structured uncertainty, Luxembourg's proactive approach, and those vital no-regrets compliance steps. We really hope this deep dive has given you a shortcut to getting up to speed, maybe sparked a few aha moments about why all this matters for your work. So, considering everything we've discussed from the human talent race to those compliance actions, here's something to think about. What new opportunity does this era of structured uncertainty and AI law present for your specific practice that maybe you hadn't considered before? Hit that like and subscribe button. Disclaimer: This podcast contains content generated or significantly edited using artificial intelligence tools. All information is provided for general informational purposes only and reflects knowledge available at the time of publication. It does not constitute financial, investment, or legal advice. We recommend that listeners verify the information independently and consult with qualified professionals for personalized advice. It was the AI Law Briefing podcast for you this week.